Hello friends, Namaskar. I am Anil Kumar Srivastav. I shall today present before you the directive principle of state policy and some part of it. Before we begin with, I would like to tell you that we have got fundamental right as a part third and fundamental uh, directives or directive principle of state policy as a part four. First of all, we should know the basic difference between the two, that the fundamental rights are important because these give meaning to the person. If these rights are not there, then the person and personality or humanity will not be there. So these are the very important articles, and if these are violated, then we find under Article 32 of the Indian Constitution, the Supreme Court is to be resorted, and under Article 226, High Court is to be resorted. The remedies can be given by these courts. But if we talk about the directive principle of state policy, this is from 36 to 51. And if we go to the 37, it especially says that these are not justiciable, meaning thereby that if the certain government does not implement these directives or principles, then the person cannot go to the court. And why these things are given in part 4? Because there are certain kind of limits to the state governments. Governments may be suffering from the scarcity of the resources or other things. Because of that, it cannot give a full implementation of these articles. So, but this is the fundamental duty of the government to implement it. Dr. Bhimrao Ambedkar on the directive principle says that I want two types of democracy. One is the political democracy, that is one person has one vote. But then we have the second kind of democracy, that is economic democracy. He talks about the economic democracy in directive principle of state policy. So the criteria of the economic democracy is fulfilled by the Article 39, 38 and 39. The policies are given in it. We talk about the social order. What is that social order? Social order is the order which is connected with the principles laid down in preamble, that is social, economic and political justice. So it is a kind of social justice. And secondly, he talk about the social justice also. Social justice is something which envisages in it the dynamics of the time. That is, the social justice will be judged according to the time. If the time changes, the person may be poorer and may be richer. So the policy should be to help these people while the state is making the policies. So the social order and social justice, these are the very important things that is to be given, that is to be implemented. And if we talk about the 39, the policies, in the policies we get that the Janata government by 44th amendment has added the 38(2), by which it has been given that the eradication of inequalities in income opportunities should be the prime objective of the state. So these principles has further been laid down for the economic democracy. If we talk about the 39 B and C talk about the resources, material resources. What will happen to the material resources? The material resources should belong to the community, belongs to the government. It should not be owned by one person, or there is no scope for monopoly. It should be monopolized. For example, the spectrum 5G belongs to the whole of India, and it belongs to the government. And government should make a provision to implement in such a manner so that everybody should get its benefit. And so the nationalization is also an important thing. The bank has been nationalized for this purpose, and there are the various things which have been nationalized to give effect to these policies. And thereafter we find that there is a section 39D, that is equal pay for equal work. Here again the government has made an important rule, that is equal remuneration for the employees, 1976 Act. And the court has said that this is a fundamental goal, and for the remedy of it we can resort to Article 32 like the fundamental right. In 39A, one important article has also been added, and that is the social justice, or for the economic justice. That is 39A has been added by 42nd Amendment Act. 43B has been added by 42nd Amendment Act. And 48A has also been added by 42nd Amendment Act. We are talking about the 39A. 39A talks about the justice, that a person is in the jail, but he has no resources to fight his case or to litigate. He has no expenses. So here the fair trial is not possible, because the person has no resources. He cannot hire a vakil, or he cannot get copies of the judgments or the other things which are needed for contesting the case. Here the provision has been made that if fair trial is not possible, if a person cannot afford the cost of the case, then here the government must come and must help, and that is why 39A has been provided. And 39A simply says that the free legal aid should be provided to those who are or who have no resources to contest their cases. And for this the amendment has been made. If we talk about the children, the children should be given the education, and for that the Article 45 has been modified. In Article 45 it has been given that from 0 to 6, the children belonging to the 0 to 6, it is the government that is duty bound for their care, and that is why the Anganwadi department is doing this thing, and the government is helping for the children. And it also held that if we talk about 39F, E and F, here it is given that the children should not be exploited, or their youth should not be exploited. If they are of the age of 6 to 14, then by 86th Amendment Act, 21A has been created as a fundamental right. It is the duty of the government under Article 21A, Fundamental Right of Education, that the government must provide free and compulsory education to the people from 6 to 14. And in the economic duties, it has also been provided that their parents should also send their children from 6 years to 14 years to the schools. So we find that there is a lot of things that has been given, and in some important cases where the exploitation of children is done, where they are sent for in the hazardous job, for match industry, etc. Article 24 should come into application. That is, a child should not be given or in a hazardous job. So government has formulated, and Supreme Court has also formulated guidelines for the children. So these are the things that have been very important for the implementation of the article under 36 to 51. If we go beyond that, we find Article 40. Article 40 says that the state shall endeavour to establish village panchayats and endow them with such powers and authority as may enable them to function as units of self-government. So what is this? This is the Panchayati Raj, and it is in this section that the Mahatma Gandhi's voice has found space. And for this we have made 72nd and 73rd amendment. For 72nd amendment, we have made democracy in the rural areas for the Gram Panchayat and the Kshetra Panchayat and the Jila Panchayat. And by 73rd amendment, we have made it compulsory for the Nagar Panchayats and the corporations in the urban areas to implement the Article 40. And now we come to the Article 41. Article 41 talks about the right to work. So right to work, everybody has got right to work, but the government has not proper funds, not sufficient funds to give them. So in employment, in education, and for all that. So what should be the duty of the government? Government should maximize its policy for giving the implementation to the Article 41 right to work. But if it is possible for them, if it has sufficient kind of funds, then it can give employment allowance to the unemployed, and like that. And Article 42 talks about the humane conditions of work, that the laborers should not be exploited. They should be given such kind of jobs, such kind of comfort and such kind of conditions in which a person can work. So Article 42 talks about the humanity or talks about the conditions, that the conditions should not be harsh for the workers and there should be a limit of the hours and other things also. And in this it is also provided that the maternity relief should also be provided, that the government should make a proposal that and make law, make statute, make legislation that the maternity relief should be done without any kind of harshness. And if we come to the Article 43, the Article 43 is a very important. It talks about the living wages. Living wages for the agricultural worker, for the industrial worker and for other workers also. The living wage, the term is very important because it talks about that the wage should be more than what is required for the shelter, for the clothes and for food, etc. That there should be more than this, the fundamental necessities. That is, we should also provide them for education and for health care. So this is the important, that is the important term which has been used as a living wage. So, and in 43A we find that the participation of worker has been given. 43A has been added or inserted in this article by 42nd Amendment Act, and in this the provision has been made that both laborer and the owner of the industry should make a provision for the division of the funds which are termed as profit. So these things are needed. So if we compare, I have already covered the half part of the directive principle of the state policy, that is, and second part of it we will cover tomorrow, and thereafter I shall cover some important cases on this. So the most important thing is that Article 37 says that it is not justiciable, and fundamental right is justiciable in accordance with the Article 32, and in other way we can say that the rights which are needed for the personality development, for the human development, are categorized under fundamental right, part 3rd, and the article which are needed for as a goal to achieve for them is adapted to state policy. So Article 3 is a means, and Article 4 and the part 4 is a goal to be achieved. So that's all for today. Thank you.